Hey crew, it's Pitt and I am back with some more freedom. And today's energetic investment into our union could not come at a more judicious time. Today we're going to be dealing with Federalist Papers number 78, 79, and 80, all dealing with the Judiciary Department. I say it's a judicious time because there are people right now calling for restrictions to be placed on the judiciary. They're not very happy with some of the members of the judiciary and their personal stances outside of the court. So we're going to see what the Federalist Papers have to say about those type of things. Let's dig in and see what's up. Federalist Paper number 78, the Judiciary Department, from McLean's Edition, New York. Authored by Alexander Hamilton to the people of the state of New York. We proceed now to an examination of the Judiciary Department for the proposed government. In unfolding the defects of the existing Confederation, the utility and necessity of a federal judicature have been clearly pointed out. It is the less necessary to recapitulate the considerations there urged, as the propriety of the institution in the abstract is not disputed. The only questions which have been raised being relative to the manner of constituting it and to its extent. To these points, therefore, our observations shall be confined. The manner of constituting it seems to embrace these several objects. First, the mode of appointing the judges. Second, the tenure by which they are to hold their places. Third, the partition of the judiciary authority between different courts and their relations to each other. First, as to the mode of appointing the judges, this is the same as with that of appointing the officers of the Union in general, and has been so fully discussed in the last two numbers that nothing can be said here which would not be useless repetition. As to the tenure by which the judges are to hold their places, this chiefly concerns their duration in office, the provisions for their support, the precautions for their responsibility. According to the plan of the convention, all judges who may be appointed by the United States are to hold their offices during good behavior, which is conformable to the most approved of the state constitutions, and among the rest, to that of this state. Its propriety having been drawn into question by the adversaries of that plan, is no light symptom of the rage for objection, which disorders their imaginations and judgments. The standard of good behavior for the continuance in office of the judicial magistrate is certainly one of the most valuable of modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. In a republic, it is no less excellent barrier to the encroachments and oppressions of the representative body. And it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. Whoever attentively considers the different departments of power must perceive that in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. This simple view of the matter suggests several important consequences. It proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power, that it can never attack with success either of the other two, and that all possible care is requisite to enable it to defend itself against their attacks. It equally proves that though individual oppression may now and then proceed from the courts of justice, the general liberty of the people can never be endangered from that quarter. So long as the judiciary remains truly distinct from both the legislature and the executive. For I agree that there is no liberty if the power of judging be not separated from the legislative and executive powers. And it proves, in the last place, that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments, that as all the effects of such a union must ensue from a dependence of the former on the latter, notwithstanding a nominal and apparent separation, that as from the natural feebleness of the judiciary, it is in continual jeopardy of being overpowered, awed, or influenced by its coordinate branches, and that as nothing can contribute to so much to its firmness and independence as permanency in office, this quality may therefore be justly regarded as an indispensable ingredient in its constitution, and, in a great measure, as the citadel of the public justice and public security. The complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains no certain specified exemptions to the legislative authority, such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all the reservations of particular rights or privileges would amount to nothing. Some perplexity respecting the rights of the courts to pronounce legislative acts void because contrary to the Constitution has arisen from an imagination that the doctrine would imply a superiority of the judiciary to the legislative power. It is urged that the authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void. As this doctrine is of great importance to all the American constitutions, a brief discussion on the ground on which it rests cannot be unacceptable. There is no position which depends on clearer principles than that every act of delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men, acting by virtue of powers, may do not only what their powers do not authorize, but what they forbid. If it be said that the legislative body are themselves the constitutional judges of their own powers, and that the construction they put upon them is conclusive upon the other departments, it may be answered that this cannot be the natural presumption, where it is not to be collected from any particular provisions in the Constitution. It is not otherwise to be supposed that the Constitution would intend to enable the representatives of the people to substitute their will to that of their constituents. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature, in order, among other things, to keep the latter within the limits of their assigned authority. The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be, regarded by the judges as fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred. Or, in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. Nor does this conclusion by any means suppose the superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature, declared in its statutes, stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decisions by the fundamental laws, rather than by those which are not fundamental. This exercise of judicial discretion in determining between two contradictory laws is exemplified in a familiar instance. It not uncommonly happens that there are two statutes existing at one time, clashing in whole or in part with each other, and neither of them containing any repealing clause or expression. In such a case, it is the province of the courts to liquidate and fix their meaning and operation, so far as they can by any fair construction be reconciled to each other. Reason and law conspire to dictate that this should be done. Where this is impracticable, it becomes a matter of necessity to give effect to one in exclusion of the other. The rule which has been obtained in the courts for determining their relative validity is that the last in order of time shall be preferred to the first. But this is a mere rule of construction, not derived from any positive law, but from the nature and the reason of the thing. It is not a rule enjoined upon by the courts of legislative provision, but adopted by themselves as consonant to truth and propriety, for the direction of their conduct as interpreters of the law. They thought it reasonable that between the interfering acts of an equal authority, that which was the last indication of its will should have the preference. But in regard to the interfering acts of a superior and subordinate authority, of an original and derivative power, the nature and reason of a thing indicate the converse of the rule that as proper to be followed. They teach us that the prior act of a superior ought to be preferred to the subsequent act of an inferior and subordinate authority, and that accordingly, whenever a particular statute contravenes the Constitution, it will be the duty of the judicial tribunals to adhere to the latter and disregard the former. It can be of no weight to say that the courts, on the pretense of a repugnancy, may substitute their own pleasures to the constitutional intentions of the legislature. This might as well happen in the case of two contradictory statutes, or it might as well happen in every adjudication upon any single statute. The courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. The observation, if it prove anything, would prove that there ought to be no judges distinct from that body. If, then, the courts of justice are to be considered as the bulwarks of a limited constitution against legislative encroachments, this consideration will afford a strong argument for the permanent tenure of judicial offices, since nothing will contribute so much as this to that independent spirit in which the judges must be essential to the faithful performance of so arduous a duty. This independence of the judges is equally requisite to guard the Constitution and the rights of individuals from the effects of those ill humors, which the arts of designing men or the influence of particular conjunctures sometimes disseminate among the people themselves, and which, though they speedily give place to better information and more deliberate reflection, have a tendency, in the meantime, to occasion dangerous innovations in the government and serious oppressions of the minor party in the community. Though I trust the friends of the proposed Constitution will never concur with its enemies in questioning that fundamental principle of republican government, which admits to the right of the people to alter or abolish the established Constitution whenever they find it inconsistent with their happiness, yet it is not to be inferred from this principle that the representatives of the people, whenever a momentary inclination happens to lay a hold of a majority of their constituents, incompatible with the provisions in the existing Constitution, would, on that account, be justifiable in a violation of these provisions, or that the courts would be under a greater obligation to connive at infractions of this shape than when they had proceeded wholly from the cabals of the representative body. Until the people have, by some solemn and authoritative act, annulled or changed the established form, it is binding upon themselves collectively, as well as individually, and no presumption or even knowledge of their sentiments can warrant their representatives in a departure from it prior to such an act. But it is easy to see that it would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution, where legislative invasions of it had been instigated by a major voice of the community. But it is not with a view to infractions of the Constitution only that the independence of the judges may be an essential safeguard against the effects of occasional ill humors in the society. These sometimes extend no further than to the injury of the private rights of particular classes of citizens by unjust and partial laws. Here, also, the firmness of the judicial magistracy is of vast importance in mitigating the severity and confining the operation of such laws. It not only serves to moderate the immediate mischiefs of those which may have been passed, but it operates as a check upon the legislative body in passing them, who, perceiving that obstacles to the success of iniquitous intention are to be expected from the scruples of the courts, are in a manner compelled, by the very motives of the injustice they mediate, to qualify their attempts. This is a circumstance calculated to have more influence upon the character of our governments than but few may be aware of. The benefits of the integrity and moderation of the judiciary have already been felt in more states than in one, and though they may have displeased those whose sinister expectations they may have disappointed, they must have commanded the esteem and applause of all the virtuous and disinterested. Considerate men of every description ought to prize whatever will tend to beget or fortify that temper in the courts, as no man can be sure he may not be tomorrow the victim of a spirit of injustice, by which he may be a gainer today. And every man must now feel that the inevitable tendency of such a spirit is to sap the foundations of public and private confidence, and to introduce in its stead universal distrust and distress. That inflexible and uniform adherence to the rights of the Constitution and of the individuals, which we perceive to be indispensable in the course of justice, can certainly not be expected from judges who hold their offices by a temporary commission. Periodical appointments, however regulated, or by whomsoever made, would in some way or another be fatal to their necessary independence, if the power of making them was committed either to the executive or legislative. There would be danger of an improper complaisance to the branch which possessed it. If to both, there would be an unwillingness to hazard the displeasure of either. If to the people, or to the persons chosen by them for the special purpose, there would be too great a disposition to consult popularity, to justify a reliance that nothing would be consulted but the Constitution and the laws. There is yet a further and weightier reason for the permanency of judicial offices, which is deducible from the nature of the qualifications they require. It has been frequently remarked with great propriety that a voluminous code of laws is one of the inconveniences necessarily connected to the advantages of a free government. To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out in their duty in every particular case that comes before them, and it will be readily be conceived from the variety of controversies which will grow out of the folly and wickedness of mankind, that the records of those precedents must unavoidably swell to a very considerable bulk, and must demand a long and laborious study to acquire a competent knowledge of them. Hence it is that there can be but few men in the society who will have sufficient skill in the laws to qualify them for the stations of judges. And making the proper deductions for the ordinary depravity of human nature, the number must be still smaller of those who unite the requisite integrity with the requisite knowledge. These considerations appraise us that the government can have no great option between fit character, and that a temporary duration in office, which would naturally discourage such characters from quitting a lucrative line of practice to accept a seat on the bench, would have a tendency to throw the administration of justice into hands less able and less qualified to conduct it with utility and dignity. In the present circumstances of this country, and in those which it is likely to be for a long time to come, the disadvantages on this score would be greater than they may appear and may at first sight appear, but it must be confessed that they are far inferior to those which present themselves under other aspects of the subject. Upon the whole, there can be no room to doubt that the convention acted wisely in copying from the models of these constitutions which have established good behavior as the tenure of judicial offices, in point of duration, and that so far from being blamable on this account, their plan would have been inexcusably defective if it had wanted this important feature of good government. The experience of Great Britain affords an illustrious comment on the excellence of the institution. And so ends Federalist Paper number 78, and we are getting the reasons why we have to separate them, right? If the legislature or the executive could be overbearing on the judiciary, it could lead to some very severe problems. It would lead to not following the Constitution. The argument that is being placed forth today is that because this man or his wife flew some flags outside of their house, that they are outside of the bounds that are placed on the court. And so far, I haven't seen that, right? You're allowed to have opinions as long as you follow the Constitution and can prove that, then you are within the judiciary rights granted to you. I don't necessarily believe that we should still have a till death appointment because when this was written, people didn't live that long, right? The average age was not much older than I am now. And people tended to die a good 20 or 30 years earlier than we are now. And so we get to the point where we have a Ginsburg situation where you are so old and decrepit that you are not actually functioning in the position, but you refuse to give it up. There is an argument that could have been made that refusing to give up the position to someone who can actually execute it could be acting outside of the bounds that were placed, right? That's not good faith. That's not good conduct. If you cannot literally do the job that you are appointed for, you should give that job up. It doesn't matter who you are. It doesn't matter what position that is. If you cannot execute the position you are in, you should give it up. But I don't know how we legislate that in particular without stepping on the bounds that are supposed to be there for the judiciary. They're supposed to be able to execute the Constitution without fear of retribution. Federalist Paper number 79, The Judiciary Department Continued, from McLean's edition, New York, authored by Alexander Hamilton, to the people of the state of New York. Next to permanency in office, nothing can contribute more to the independence of the judges than a fixed provision for their support. The remark made in relation to the President is equally applicable here. In the general course of human nature, a power over a man's subsistence amounts to a power over his will, and we can never hope to see realized in practice the complete separation of the judicial from the legislative power. In any system which leaves the former dependent for pecuniary resources on the occasional grants of the latter, the enlightened friends to good government in every state have seen cause to lament the want of precise and explicit precautions in the state constitutions on this head. Some of these, indeed, have declared that a permanent salary should be established for the judges, but the experiment has in some instances shown that such expressions are not sufficiently definite to preclude legislative evasions. Something still more positive and unequivocal has been evinced to be requisite. The plan of the convention, accordingly, has provided that the judges of the United States shall, at stated times, receive for their services a compensation which shall not be diminished during their continuation in office. This, all circumstances considered, is the most eligible provision that could have been devised. It will readily be understood that the fluctuations in the value of money and in the state of society rendered a fixed rate of compensation in the Constitution inadmissible. What might be extravagant today might in half a century become penurious and inadequate. It was therefore necessary to leave it to the discretion of the legislature to vary its provisions in conformity to the variations in circumstances, yet under such restrictions as to put it out of the power of that body to change the condition of the individual for the worse. A man may then be sure of the ground upon which he stands, and can never be deterred from his duty by the apprehension of being placed in a less eligible situation. The clause which has been quoted combines both advantages. The salaries of judicial officers may from time to time be altered, as occasion shall require, yet so as never to lessen the allowance with which any particular judge comes into office in respect to him. It will be observed that a difference has been made by the convention between the compensation of the president and of the judges, that of the former can neither be increased nor diminished, and that of the latter cannot only be diminished. This probably arose from the difference in the duration of their respective offices, as the president is to be elected for no more than 4 years, and it can rarely happen that an adequate salary fixed at the commencement of that period will not continue to be such to its end. But with regard to the judges, who, if they behave properly, will be secured in their places for life, it may well happen, especially in the early stages of the government, that a stipend, which would have been very sufficient at their first appointment, would become too small in the progress of their service. This provision for the support of the judges bears every mark of prudence and efficiency, and it might be safely affirmed that together with the permanent tenure of their offices, it affords a better prospect of their own independence than is discoverable in the constitutions of any of the states in regard to their own judges. The precautions for their responsibility are comprised in the article respecting impeachments. They are liable to be impeached for malconduct by the House of Representatives, and tried by the Senate, and, if convicted, may be dismissed from office and disqualified from holding any other. This is the only provision on the point which is consistent with the necessary independence of the judicial character, and is the only one which we find in our own Constitution in respect to our own judges. The want of a provision for removing the judges on account of inability has been a subject of complaint, but all considerate men will be sensible that such a provision would either not be practiced upon, or would be more liable to abuse than calculated to answer any good purpose. The mensuration of the facilities of the mind has, I believe, no place in the catalogue of known arts. An attempt to fix the boundary between the regions of ability and inability would much oftener give scope to personal and party attachments and enmities than advance the interest of justice or the public good. The result, except in the case of insanity, must for the most part be arbitrary, and insanity, without any formal or express provision, may be safely pronounced to be a virtual disqualification. The Constitution of New York, to avoid investigations that must forever be vague and dangerous, has taken a particular age as the criterion of inability. No man can be a judge beyond 60. I believe there are few at present who do not disapprove of this provision. There is no station in relation to which it is less proper than that of a judge. The deliberating and comparing faculties generally preserve their strength much beyond that period in men who survive it. And when, in addition to this circumstance, we consider how few there are who outlive the season of intellectual vigor, and how improbable it is that any considerable portion of the bench, whether more or less numerous, should be in such a situation at the same time, we shall be ready to conclude that limitations of this sort have little to recommend them. In a republic, where fortunes are not affluent and pensions not expedient, the dismission of men from stations in which they have served their country long and usefully, on which they depend for subsistence, and from which it will be too late to resort to any other occupation for a livelihood, ought to have some better apology to humanity than is to be found in the imaginary danger of a superannuated bench. And so ends Federalist Papers number 79, and they talk about the very problem that I was just talking about. And while it was not anticipated then that we'd have pharmaceuticals that could extend your life well past 100, it is a reality today. We do indeed have several members who are approaching infirmity now. Currently, I don't believe that there are any that are actually unfit in that particular position, right? But the Ginsburg situation is a good one because she was physically unable to commit to her job, right? She couldn't go into court. She couldn't pass judgment. She was physically incapacitated, and we had no way to remove that. That's a problem. Now, the mental acuity, that's a little bit harder to discern. But what happens if we get a judge with dementia? Like, what happens in the case that we have a judge who has, a traumatic brain injury and suddenly becomes irrational? We don't have the means for removing that. And that's a problem. I'm not going to say that I have the answer to that problem, but it is something that does need to be anticipated as we are extending the lives of our citizens, of our populace. It is not unreasonable to expect that in the next 50 years there will be medical advances that extend human life well beyond 120 years. And then we are really getting into the wear and tear of the old celluloid there. Federalist Paper number 80. The Powers of the Judiciary, from Maclean's edition, New York, authored by Alexander Hamilton, to the people of the state of New York. To judge with accuracy of the proper events, of the proper extent of the federal judicature, it will be necessary to consider in the first place what are its proper objects. It seems scarcely to admit of controversy that the judiciary authority of the Union ought to extend to these several descriptions of cases. First, to all those which arise out of the laws of the United States, passed in pursuance of their just and constitutional powers of legislation. Second, to all those which concern the execution of the provisions expressly contained in the Articles of the Union. Third, to all those in which the United States are a party. Fourth, to all those which involve the peace of the Confederacy, whether they relate to the intercourse between the United States and foreign nations, or to that between the states themselves. Fifth, to all those which originate on the high seas, and are of admiralty or maritime jurisdiction. And lastly, to all those in which the state tribunals cannot be supposed to be impartial and unbiased. That's a good one. The first point depends upon this obvious consideration that there ought always to be a constitutional method of giving efficacy to the constitutional provisions. What, for instance, would avail restrictions on the authority of the state legislatures without some constitutional mode of enforcing the observance of the states by the plan of the convention are prohibited from doing a variety of things, some of which are incompatible with the interests of the Union, and others with the principles of good government. The imposition of duties on imported articles, and the emission of paper money, are specimens of each kind. No man of sense will believe that such prohibitions would be scrupulously regarded, without some effectual power in the government to restrain or correct the infractions of them. This power must either be a direct negative on the state laws, or an authority in the federal courts to overrule such as might be in manifest contravention to the Articles of the Union. There is no third course that I can imagine. The latter appears to have been thought by the convention preferable to the former, and I presume will be most agreeable to the states. As to the second point, it is impossible, by any argument or comment, to make it clearer than it is in itself. If there are such things as political axioms, the propriety of the judicial power of the government, being coextensive with its legislative, might be ranked among the number. The mere necessity of uniformity in the interpretation of the national laws decides the questions. 13 independent courts of final jurisdiction over the same causes, arising upon the same laws, is a hydra in government, from which nothing but contradiction and confusion can proceed. Still less needs to be said in regard to the third point. Controversies between the nation and its members or citizens can only be properly referred to the national tribunals. Any other plan would be contrary to reason, to precedent, and to decorum. The fourth point rests on this plain proposition that the peace of the whole ought not to be left at the disposal of a part. The Union will undoubtedly be answerable to foreign powers for the conduct of its members, and the responsibility for an injury ought ever to be accompanied with the faculty of preventing it, as the denial or perversion of justice by the sentence of courts, as well as in any other manner, is the reason classed among the just causes of war. It will follow that the federal judiciary ought to have cognizance in all causes in which the citizens of other countries are concerned. This is not less essential to the preservation of the public faith than to the security of the public tranquility. A distinction may perhaps be imagined between cases arising upon treaties and the laws of nations and those which may stand merely on the footing of the municipal law. The former kind may be supposed proper for the federal jurisdiction and the latter for that of the states, but it is at least problematical whether an unjust sentence against a foreigner, where the subject of controversy was wholly relative to the lex loci, would not, if unredressed, be an aggression upon his sovereign, as well as one which violated the stipulations of a treaty or the general law of nations. And a still greater objection to the distinction would result from the immense difficulty, if not impossibility, of a practical discrimination between the cases of one complexion and those of the other. So great a proportion of the cases in which foreigners are parties involve national questions that it is by far most safe and most expedient to refer all those in which they are concerned to the national tribunals. The power of determining causes between two states, between one state and the citizens of another, and between the citizens of different states is perhaps not less essential to the peace of the Union than that which has just been examined. History gives us a horrid picture of the dissensions and private wars which distracted and desolated Germany prior to the institution of the imperial chamber by Maximilian, towards the close of the 15th century, and informs us at the same time of the vast influence of that institution in appeasing the disorders and establishing the tranquillity of the empire. This was a court invested with authority to decide finally all differences among the members of the Germanic body. A method of terminating territorial disputes between the states under the authority of the federal head was not unattended to, even in the imperfect system by which they had been hitherto held together. But there are many other sources, besides interfering claims of boundary, from which bickerings and animosities may spring up among the members of the Union. To some of these we have been witnesses in the course of our past experience. It will readily be conjectured that I allude to the fraudulent laws which have been passed in too many of the states. And though the proposed Constitution establishes particular guards against the repetition of those instances which have heretofore made their appearance, yet it is warrantable to apprehend that the spirit which produced them will assume new shapes, that it could not be foreseen nor specifically provided against. Whatever practices may have a tendency to disturb the harmony between the states are proper objects of federal superintendence and control. It may be esteemed the basis of the Union that the citizens of each state shall be entitled to all the privileges and immunities of citizens of the several states. And if it be a just principle that every government ought to possess the means of executing its own provisions by its own authority, it will follow that in order to the inviolable maintenance of that equality of privileges and immunities to which the citizens of the Union will be entitled, the national judiciary ought to preside in all cases in which one state or its citizens are opposed to another state or its citizens. To secure the full effect of so fundamental a provision against all evasion and subterfuge, it is necessary that its construction should be committed to that tribunal which, having no local attachments, will be likely to be impartial between the different states and their citizens, and which, owing its official existence to the Union, will never be likely to feel any bias inauspicious to the principles on which it is founded. The fifth point will demand little animadversion. The most bigoted idolizers of state authority have not thus far shown a disposition to deny the national judiciary the cognizance of maritime causes. These so generally depend on the law of nations and so commonly affect the rights of foreigners that they fall within the considerations which are relative to the public peace. The most important part of them are, by the present Confederation, submitted to the federal jurisdiction. The reasonableness of the agency of the national courts in cases in which the state tribunals cannot be supposed to be impartial speaks for itself. No man ought certainly to be a judge in his own cause, or any cause in respect to which he has the least interest or bias. This principle has no inconsiderable weight in designating the federal courts as the proper tribunals for the determination of controversies between different states and their citizens. And it ought to have the same operation in regard to some cases between citizens of the same state. Claims to land under grants of different states, founded upon adverse pretensions of boundary, are of this description. The courts of neither of the granting states could be expected to be unbiased. The laws may even have prejudged the question and tied the courts down to decisions in favor of the grants of the state to which they belonged. And even where this had not been done, it would be natural that the judges, as men, should feel a strong predilection to the claims of their own government. Having thus laid down and discussed principles which ought to regulate the constitution of the federal judiciary, we will proceed to test, by these principles, the particular powers of which, according to the plan of the convention, it is to be composed. It is to comprehend all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same states, claiming lands and grants of different states, and between a state or the citizens thereof and foreign states, citizens and subjects. This constitutes the entire mass of the judicial authority of the Union. Let us now review it in detail. It is, then, to extend. First, to all cases of law and equity arising under the Constitution and the laws of the United States. This corresponds with the two first classes of causes, which have been enumerated as proper for the jurisdiction of the United States. It has been asked, what is meant by cases arising under the Constitution, in contradiction from those arising under the laws of the United States? The difference has already been explained. All the restrictions upon the authority of the state legislatures furnish examples of it. They are not, for instance, to emit paper money, but the interdiction results from the Constitution and will have no connection with any law of the United States. Should paper money, notwithstanding, be emitted, the controversies concerning it would be cases arising under the Constitution and not the laws of the United States, in the ordinary signification of the terms. This may serve as a sample of the whole. It has also been asked, what need of the word equity? What equitable causes can grow out of the Constitution and laws of the United States? There is hardly a subject of litigation between individuals which may not involve those ingredients of fraud, accident, trust, or hardship, which would render the matter an object of equitable rather than of legal jurisdiction. And the distinction is known and established in several of the states. It is the peculiar province, for instance, of the Court of Equity to relieve against what are called hard bargains. These are contracts in which, though there may have been no direct fraud or deceit sufficient to invalidate them in a court of law, yet there may have been some undue and unconscionable advantage taken of the necessities or misfortunes of one of the parties, which a court of equity would not tolerate. In such cases, where foreigners were concerned on either side, it would be impossible for the federal judicatories to do justice without an equitable as well as legal jurisdiction. Agreements to convey lands claimed under the grants of different states may afford another example of the necessity of an equitable jurisdiction in the federal courts. This reasoning may not be so palpable in those states where the formal and technical distinction between law and equity is not maintained, as in this state, where it is exemplified by everyday practice. The judiciary authority of the Union is to extend. Second, to the treaties made, or which shall be made under the authority of the United States, and to all cases affecting ambassadors, other public ministers, and consuls. These belong to the fourth class of the enumerated cases, as they have an evident connection with the preservation of the national peace. Third, to cases of admiralty and maritime jurisdiction. These form, altogether, the fifth of the enumerated classes of causes proper for the cognizance of the national courts. Fourth, to controversies to which the United States shall be a party. These constitute a third of those classes. Fifth, to controversies between two or more states, between a state and citizens of another state, between citizens of different states. These belong to the fourth of those classes and partake, in some measure, of the nature of the last. Sixth, to cases between the citizens of the same state, claiming lands under the grants of different states. These fall within the last class and are the only instances in which the proposed Constitution directly contemplates the cognizance of disputes between citizens of the same state. Seventh, to cases between a state and the citizens thereof, and foreign states, citizens, or subjects. These have already been explained to belong to the fourth of the enumerated classes, and have been shown to be, in a peculiar manner, the proper subjects of the national judicature. From this review of the particular powers of the federal judiciary, as marked out in the Constitution, it appears that they are all conformable to the principles which ought to have governed the structure of that department, and which were necessary to the perfection of the system. If some partial inconveniences should appear to be connected with the incorporation of any of them into the plan, it ought to be recollected that the national legislature will have ample authority to make such exceptions, and to prescribe such regulations as will be calculated to obviate or remove these inconveniences. The possibility of particular mischiefs can never be viewed by a well-informed mind as a solid objection to a general principle, which is calculated to avoid general mischiefs and to obtain general advantages. And so ends Federalist Paper number 80. And here we have the delineation of jurisdiction more than anything. They should have jurisdiction over cases between states, between a person and another state. Like all of this, I absolutely agree with. We do need a judiciary that handles things on that level, separate from the one that handles on the local or state levels. But you should have them as a recourse to fight against your state, and that is what is outlined here. The only part really to discuss is the part bearing to why it's so judicious that we're doing this today, and that is, are they operating in good conduct, or does the judge flying a flag, right? One of them was an upside down flag, and one of them was a flag from the Revolutionary War. Yet somehow that has been construed to mean that he is sympathetic to the events that happened in January a few years ago that we're not going to talk about because we don't want to get banned in the land of free speech. And so I don't see how him flying a flag shows preferential treatment to anyone in particular. Both of the things that it was done was well within the bounds of free speech and not laying into any particular course. As a matter of fact, these things are exactly what his jurisdiction should be. Now, it is perfectly fine to be a patriot in the judiciary. It is not fine to be biased in the judiciary, whether that's to my side or to your side or to whoever side sees it. There should be no bias. That's why we have the restrictions placed upon them in good order. If they are following the Constitution, and it is clearly defined in their statements, in their judgments, in their findings, if it is clearly laid out that this is the constitutional precedent, you have no grounds by which to talk. You cannot exclude someone from being part of the judiciary who is to determine whether or not citizens are to be permanently punished for crimes that may or may not even be crimes simply because they think that the country is in distress. I think that the country is in distress too. I can see what inflation is doing. I can see what the policies being enacted are doing. If you can't, then you're probably slanted to one side. I saw what policies were doing on the other side too. I tend to stay right in the middle. Hopefully I brought a little bit of enlightenment and not too much confusion to a somewhat difficult topic. We have 5 more papers, I believe. We'll probably wrap that up in the next sitting, but so far I don't see any reason why any of the judges should be excluded from either side. Like, if you are showing bias, like there have been, Ketanji Brown absolutely has shown judicial bias already. But this is a person that cannot define basic biology, so I'm not entirely surprised. The fact that we have a member of the judiciary who cannot define biological facts is an enormous problem. That's a problem. I don't care what her political leanings are. The fact that she cannot define a biological certainty is a problem. To the crew, thanks for hanging out. I appreciate every single minute that you are here with me, and I am praying for you every single day. Until next time, I love you. God loves you. You are perfect, whole, and complete just the way that you are. And this has been Pitt State. Peace.